My name is attorney Howard Ankin. I've been practicing workers' compensation law in the city of Chicago for the past 26 and a half years on behalf of petitioners or injured workers. Today's topic is settlement contracts. You can find the form settlement contract like you could find all other forms on the workers' compensation law website. When you would go download the settlement contract, or what is commonly known in parlance as the pink sheet, you will find that on the backside or page 2 that there's a paragraph that's left blank to fill in the language of the settlement. When most people start out practicing workers' compensation law, either on the respondent or the petitioner's side, they typically get either from the firm that they're working in or from a lawyer that's helping them their form documents. If you have a very standard case, this may be right for you. However, it is good to know what's in the pink sheet because your case may require it. 25 years ago, it was a lot easier to use form language. Today, especially following the 2011 law changes, there's things that are in the law as well as on the workers' compensation website form pink sheet, which need to be determined on a case-by-case basis what's needed. And there are things in that form contract from the commission which need to be whited out or modified because they don't exactly match the intention of what you may get in your language on the backside of the contract. In addition to that, especially when it comes to medical bills, when you're about 2/3 down on the first page of the front page of the form pink sheet, which talks about medical bills, that language there needs to match exactly what's on the backside of the contract. The arbitrators these days are looking very carefully at submitted pink sheets, and they will send back any pink sheet which does not have that language matched up. In addition to that, although the arbitrators are very careful to review the pink sheets, there may be things that you need in your pink sheet which the arbitrator is not looking for. One of those issues is if you have an injured worker who is Medicare eligible, it's important to have in your language that if Social Security or Medicare needs to be modified, the parties are allowed to contract under commission rules to make that modification, and it is good practice to put in your pink sheets that you have that right. Section 19H of the Act historically has always stated that it is eliminated for the future in the pink sheet. That means that the injured worker cannot come back within 2.5 years if there's a change in circumstances and that the settlement is a final settlement on permanency. In addition to that, under Section 5B, there may be another third party or tort case for which there is a recovery. Respondents typically want to make sure that they are entitled to get their 75% of what they've paid out back under the law, and they want to have that Section 5B in. I am not so sure today that under case law that you absolutely have to have Section 5B in your pink sheets, but that is also good practice. The right to future medical care and treatment historically is always removed from the contracts. However, if you have a seriously injured worker, you may want to make sure that Section 8A for future medical, or the right to future medical is left open, then giving the right to respondent to close it once they have a Medicare set aside if they so choose. In addition to that, under 2011 law changes, 8.7 of the Act, which talks about utilization review, would give a respondent the right to get utilization review at any time for outstanding medical bills, even once contracts are approved, so that there's no hard feelings between a respondent or a petitioner. The determination of what would happen with outstanding medical bills should definitely be decided at the time of contracting and not being left open to future. However, an unknowing petitioner putting in a contract that necessary and reasonable bills would be decided later without removing the right of 8.7 to the respondent could be not beneficial to an injured petitioner who settled the case, not knowing that they would have to pay for outstanding medical bills later. These are the main points that need to be put into a settlement contract. And again, anybody who needs assistance can usually find a learned person at the commission that can help you look over your contracts or assist you for your first time, or if you have something special in your contracts that needs to be reviewed. You can always ask the respondent to go before the arbitrator in a pretrial setting to discuss pink sheets if that is another tactic that you feel that you would like to use. To learn more about the benefits of joining our ISBA Workers' Compensation Law section, please visit the ISBA website. Additionally, if you're looking for a form contract If you have basic questions or you have specific questions on pink sheets, please feel free to contact me at my office at 312-600-0000 or at Howard@AnkinLaw, ANKIN law.com.